at the end of the presentation. Okay, so with that, let's begin. Again, Adam Nyhan, I'm an attorney at a law firm in Portland, Maine called Perkins Thompson. I'm in the software and business law and intellectual property groups there. I've been basically representing software companies since I think 2004, which explains some of the gray whiskers you can see in my beard. I also spent a couple of years as a co-founder of a SaaS company in Los Angeles in the sort of legal tech space, which is a huge niche, and also on the business and legal sides of a second startup in New York City. So I've spent probably not as much time as all of you on the non-legal side of the trenches of startups, but I've been on both sides of the table between the business client and the lawyer. And I like to look at both sides of how we solve the problems that come up in selling software products. So with that said, real quick, here's what we're going to cover today. Let me just make sure my Q&A, yeah, okay, Q&A looks like I can still see it. We're going to talk about, obviously, SaaS. We're going to start with some real fundamentals because all of you are very deeply familiar with SaaS, what it is, but what you may not be as familiar with is how the legal system thinks about SaaS. And that's important because it is a product that you're making, selling, licensing, in some cases also buying. And as part of that, in addition to understanding how the business works and how your market works and how to deal with your employees and customers, you also want to know how the legal system treats your product because that may become important down the line. Not just in the event of a dispute, but it also helps you sort of understand your options for commercializing your products. So we're going to talk about when and how do you actually form a SaaS company? So there's a range of people on this call. Some of you I know are with very well-established SaaS companies that have been around for years and have large numbers of employees. Some of you are just beginning to dip your toe into the water of SaaS. Maybe your day job is with a large employer, but you're beginning to think about doing your own SaaS startup, or maybe you're somewhere in between. So we're going to try to cover this for everyone from all points on that spectrum. So the first question is, when and how do you want to actually form a SaaS company? Because most startups are not incorporated. They start out as 1, 2, sometimes 3 people in the garage, at a co-working space, whatever it is. And at some point you need to deal with the question, when do we form a company? Then we're going to talk about how the law views the SaaS product itself. We're going to talk about how to make sure that you can actually legally sell the product that you're trying to sell or license to people. We're going to go through in a fair amount of detail and look at common examples of SaaS agreements. We're going to actually look at some. I've pulled some from various websites that you've probably seen before or used before. And we're going to kind of go through and make sure we understand how to map the theory to what it actually looks like in practice. And then at the end, we just have some random tips and tricks and sort of pro tips to keep in mind as you go out and try to sell SaaS. All right, forming a company. Okay, again, the question is, when is it time to go from a sole proprietor? But sole proprietor, when you hear that phrase, it literally just means anyone who's not organized as a company. When we say company, 99.9% of software companies in the United States are going to be organized either as a corporation or as an LLC. Both of them are totally fine in the beginning stages. You'll read a lot of articles that say, you have to be a C corporation from day one. It's not true. Those articles are generally written by lawyers or investors who are in New York City or Silicon Valley. They have a bias towards a particular way of working with folks in those larger markets. It's absolutely acceptable, particularly if you're in Maine or Oklahoma or a smaller market. It's absolutely fine to start out as an LLC. I've got plenty of clients who start out as an LLC. There's nothing wrong with that. It's easy enough when the time comes, you can convert into a corporation, specifically a Delaware corporation. Typically that happens when it's time to either take on investors or be acquired. Plenty of time to do that down the line. If you're already organized as an LLC, don't worry about it. You didn't do anything wrong. The question is, when do we want to form this company? And what I tell people is, think of it this way. When any one of the following sort of what I'll call trigger scenarios becomes true, whenever you can answer yes to any of these bullet points, it's probably time to form a company. Again, talk to a lawyer to sort of confirm it because your mileage can vary, but this is generally what we say. Form a company when one of the following is true. Either the product is a B2B SaaS product as opposed to B2C. And let's just stop there and make a threshold sort of distinction. SaaS is SaaS for the most part, but there are pretty big distinctions between making and selling a consumer SaaS product versus B2B. The main consideration is, aside from sort of revenue issues and strategies, Consumer SaaS, of course, no one's going to be negotiating the agreement between you and your customers or your users. It's just an online agreement. It's a click wrap agreement or a shrink wrap agreement. And if you use the product, then you have to agree with that terms of service. Very different situation for B2B SaaS companies. These agreements are often heavily negotiated, or at least in the early days until you figure out what your potential customers want the product to look like and the agreement to look like, and then it tends to sort of flatten out the negotiations. But the first bullet point here is it's probably time to form a company when the product is a B2B product. If it's a B2C SaaS product, it's probably fine for a while in the early days to not be incorporated. It's okay if there's low risk to you, it's okay. B2B, you kind of need to be a company from day one. Also, if you have a really significant number of users, there's no sort of magic number here, but the more users, the more risk that something is going to happen sort of badly with your product, the more risk that someone is going to be upset with you, potentially try to sue you. Or third option would be if you have significant amount of sales, okay, which is different from users. You could have a very small number of customers, but one or two big enterprise SaaS customers pay an awful lot of money for a 5-year subscription to your product. It's a good problem to have if you have a big insurance company or bank or whatever that wants to pay you, $2 million for a 5-year subscription. But boy, does that create risk for you. So you want to be incorporated, because remember, forming a company is what protects the business owners from all of those risks that are inherent in running a business. Another issue would be if there's a significant risk to customers that could result from using the SaaS product. And the way to think about this is, theoretically, what is the harm that my SaaS product or our SaaS product could possibly cause to customers or users if they are using it? So think of it this way. If any of you are people who like to play mobile phone games, you play any of those games by Zynga, Candy Crush or whatever those are, if something bad happens, I mean, it's a bad example because that's not SaaS, that's actually downloaded software, but you get the point. If you're a Zynga and your game malfunctions, the worst thing that can possibly happen is that someone doesn't get to play your game for a couple hours, okay? No one's gonna sue you over that. Contrast that with if you're a company that's in the business of making software that's used by hospitals to keep people alive. All that software that runs in the background that you never think about, that runs the hospitals or runs a veterinarian clinic, if that software malfunctions, whether it's a sort of unplanned downtime, when it's the software that powers someone's ventilator, or when it's something that just produces data that screws with the results that's being needed by the healthcare organization, obviously high risk. Someone could literally die because of your software malfunction. So the point here is if the nature of your software presents some risks for customers, you want to form the company because the risk to the owners of the company of doing business without a company increases. Couple other things here. If you have multiple people who are contributing intellectual property to the product, you probably want to have a company. It's okay in the early days if 2 or 3 friends are sort of coding together, or one is the coder and the other one does all the graphic design and the written copy. That's fine. You can do that for a while. I get it. Not everyone needs to rush out and form a corporation the second they start working together. That would be unrealistic, probably unnecessarily expensive. But when you have people really contributing large amounts of work for more than a brief period of time, you want to form a company for one simple reason, which is you need to have one sort of neutral party that actually owns all that intellectual property. Because what the worst thing that can happen is you've got a company or no company, but you've got multiple people creating IP, intellectual property, that becomes part of the product, but no one actually owns it, because it means now all of them have veto power over anything that any of them might want to do to actually commercialize the product. If you and I are working together, I don't want you to sell your product to such and such a company. I can veto it because you need my IP. Best thing is to have everyone assign their IP to one company, which in turn sells or licenses it to others. We'll talk about this in more depth. Last, it's time to form a company if you want outside investors. Investors don't invest in ideas. They don't invest in products. They don't invest in, you'll hear a lot of investors say, well, I invest in teams. But to be more specific, they invest in teams that are organized in the form of a company. You will not be able to get a real investor, maybe a loan from a friend or family, but you will not get any real investment if you don't have a company. That is literally what they are investing into, is where do I put my money and what do I get in return? All right, so real quick on this, what kind of company do you want to form? Again, as I mentioned, most software companies are going to be either a corporation or an LLC. Either one is fine in the beginning. What I would say, you'll see a lot of blogs, legal articles, things written by investors, again, in the bigger cities. They're going to tell you you have to be a Delaware corporation, specifically a Delaware C corporation. You don't want to be an S corporation. By the way, if there's anybody on this call, quick timeout, if there's anybody on this call who has a company that is currently taxed as an S corporation, which is not all, but sometimes people get advice or they do it themselves and they are taxed as an S corporation. If that's the case, it's not a crisis, but do talk to your business lawyer and your accountant sort of sooner rather than later if you ever want to get investment, because investors cannot, institutional investors are not able to invest in S corporations. So you need to change that if you want to take on an investment. Anyway, what I would say in general is if the following three things are true, then you probably want to be a Delaware C corporation from day one. If there's a good chance that you will seek equity investors, not debt financing, not a loan, but actual equity investors in the near term. And if those folks are likely to be outside of your home state, then probably be a Delaware C corporation. And the home state issue is important because if you're dealing, like, for example, the folks in the state of Maine, some of you have gotten investment from, Maine Technology Institute, equity investment from Maine Technology Institute, Maine Venture Fund, Maine Angels or Bangor Angels. All those folks are absolutely comfortable, last time I checked, investing in LLCs. Not a problem, it doesn't faze them. But that's because they're in Maine and they're familiar with the Maine LLC laws. If you're a company in Maine, let's say, that wants to take investment from an investor in Portland, Oregon, Silicon Valley, New York, 99.5% of the time they're going to say, we don't know anything about Maine LLC law. Just become a Delaware corporation. We'll be happy to talk more about investing. And that's why you'll see, by the way, if you have friends in the Maine startup community, you'll see that often around the same time a company announces a big Series A round, they've converted from a Maine LLC or corporation to a Delaware corporation. That's the issue there. It happened again in the last couple months with a couple folks because the investors said, we need to have you be a Delaware corporation if we can incorporate. If any of these is not true, just form the company in the state where you're actually based and reorganize it later. Again, it's easy enough to do. Yeah, there's a little bit of cost to it, but it's trivial in the scheme of things. It's very easy to incorporate, to reorganize from a Maine LLC or corporation to a Delaware C corporation. So that's it. Let's move on from that. That's sort of basic housekeeping. We're going to talk about, like, what is SaaS anyway? Legally, I mean. Because again, you all know what SaaS is. So if you're on this call, it means you either currently own a SaaS company or you're familiar enough with SaaS to really start spending time thinking about what you want to do with it as your next growth phase. The point is you're familiar with it as a product and as a way of thinking about distribution. But what you may not be familiar with deeply is, like, legally, what is it actually? Because we all kind of know what SaaS is, right? It's the SaaS product, it's the platform. But legally, this is important to understand because the software agreement, the customer agreement you're going to sign with your customers, in some cases your users. Remember, depending on the SaaS product, sometimes the customers are not the same people as the users. But we'll get into that, and I think you know the issue that I'm talking about. But the product, legally, the way that lawyers and the justice system, the legal system and courts and the contracts think about the SaaS is the product is the customer's legal rights. That's right. The product is actually legal rights that you are going to be giving, selling to your customers. They are the rights to access and use a couple things that together we call the SaaS product, which is essentially, in big buckets, the code that powers the product, the application code, the user interface, and the content that appears in it. I kind of put these into three conceptual buckets. There's the code that powers the product, there's the user interface, and then everything that people can actually click on, see, read, listen to in some cases through the user interface. Together, those are what the customer is buying the right to access and use in ways that are going to be defined in the customer agreement. In a second, we're going to go through and actually look at examples of those customer agreements so we can see sort of in the wild what this looks like. Now, at the bottom of the slide, also notice that in some cases, not all, this depends on what kind of SaaS product you are. In some cases, the product is also the user's or the customer's right to not only access and use the SaaS platform, but actually to publish or display content there. So for example, as consumers, most of us are users of Facebook and YouTube. Some of you may use Hacker News or Quora or Stack Overflow, those forum discussion sites. In all of those cases, you are paying as a customer, or not paying, and not all of them are the paid products, but you are getting the ability not just to sort of read and see stuff that's on the platform, but also to use it as your own personal publishing platform. So again, depending on the product, you'll see this actually defined in the contract saying, you know, how does this go? By the way, if this were an in-person presentation, I would take a quick timeout and say, any questions? I'll do the same thing here. I've been keeping an eye, when I glance off screen, it's because I'm keeping an eye on the Q&A chat function. I don't see any questions. Feel free to just chime in as we go on the fly if something I said didn't make sense, or if I'm talking too fast, or any of the above. I did get a note from Kelsey that I'm waving my hands around and that's making it hard to hear, so I'll try to sit on my hands. Okay, seeing no questions, I'm gonna proceed here. If I can get back to my, okay. All right, so we've talked about how the law views SaaS and how contract law views SaaS. It is this collection of rights that you're selling to people. But let's just pause for a second, because conceptually, and in fact, very practically, legally, you cannot sell any of that stuff. You cannot sell that rights to use your SaaS product until you, the company itself, actually owns it. When I say you here, I mean, you know, again, for our previous conversation, I'm assuming you as a company, but this would also apply to you if you have not yet organized the company. You, the person or company that's providing the SaaS product. You can't sell it until you actually own it. And what I mean by that is that under the US copyright laws, and we're talking about copyright because copyright law is the area of law that governs who like literally owns all the stuff that goes into SaaS. So if we think of stuff that is the components of SaaS, you can break these down any way you want. I kind of mentally organize these as the source code and the object code, the user interface and UX elements, all the content that's in the product, everything the human being can see in the front end, the text, the artwork, the videos, you know, the database structure itself. There's been some debate about this in the courts over the year, but the way the law stands right now is certain elements of the database structure can actually be protected by copyright, not the individual sort of you know, little tiny character strings that might appear in there, but the overall structure of the database can sometimes be protected by copyright. You may have also noticed or read there's a vicious lawsuit going on right now that hopefully will be resolved by the Supreme Court in the next term, which deals with APIs. The case is Google versus Oracle, if you want to read about it. In a nutshell, it raises two questions. Are APIs protectable by copyright? And then if the answer to that is yes, can someone who wants to use the API sort of get around that by relying on what's called the fair use defense, which is very, very confusing area of copyright in general, especially when it comes to software and APIs. So the bottom line, all I'm trying to get across here is for most parts, most elements of what we think of as the components of SaaS, the law is very clear that they're protected by copyright. Some like APIs, there's a confusion over it, but it will be resolved soon. I'm hearing a couple little dings on my system. I don't think that's coming from questions. I'm going to move on. Okay, so the key thing to know is that by law, by copyright law, the individual people who create that stuff, the components of SaaS, by default, they all own it until they enter into a written agreement with a company that says now the company can own it. Now, a little bit of an asterisk on that, because in the case of employees, so not contractors or freelancers, but actual employees, generally the company owns the work created by the employees, but it doesn't hold true in all cases. So I'll explain what we mean. How you want to ensure that the company owns the product? Well, luckily there's a very simple tool that you have to make sure this happens. It's a simple written agreement. Different lawyers call it different things. In your company, it may be called a work for hire agreement. That's usually done with contractors. Or it might be called an IP assignment or an intellectual property transfer agreement, or it may just be one clause that appears in a longer employment contract between the employee and the company. But the point is, whatever your company calls these documents, the easiest thing the most important thing I can ask you to take away from, frankly, this entire thing, this entire presentation, every person and company that is helping you, the software provider, create the SaaS product absolutely has to sign a written agreement. It has to be in writing or it's not legally valid under the copyright laws that gives ownership of the work that they create. And again, the source code that they write, the UI stuff that they create, whatever that stuff is, everybody needs to sign a written agreement that hands over the rights of ownership to the company itself. So that's going to be done by your freelancers and contractors. If you're like most software companies, you rely often very heavily on freelancers, independent contractors. This is true more in software than most other industries. Nothing wrong with it, but there's a slightly different type of written agreement they need to have. If you use The second bullet point here is maybe not an individual freelancer, but a subcontracted development firm. Very common too. You know, one company is making a SaaS product. They need some particular expertise with like a DevOps issue or some HIPAA compliance thing or whatever. They contract out part of the work to another shop. It's not a freelancer, it's just a subcontractor. They all need to sign the contracts doing this. And then again, like I mentioned before, employees, some of you may have read this, and it is true, under the copyright laws, by default, employees, so actual people who get paid with a W-2, not a 1099, employees generally, if they create intellectual property, the company that employs them is going to be considered the owner. But the part of this that people always forget, and this is critical, and this is why I don't want you to rely on that, in other words, I want you to have them sign an agreement anyway, is that rule only applies to the extent that the employee's job duties, literally their duties on paper, include the creation of that intellectual property. Okay, and the problem is if you're like most software companies, people change hats pretty frequently. Some person who you thought you were hiring as your, you know, assistant VP of engineering, well, it turns out that she's actually a rock star on the sales side. So you're going to put her over in sales or vice versa. It's fairly common, especially for startups, not to actually have any written employment agreement, which, by the way, you need to have one legally. But the reality is people often don't have an employment agreement in writing. So don't rely on that default rule of copyright. Again, bottom line is make sure everyone signs this. And here's just a sort of visual way to sort of, I think, make sense of this. The IP chain is sort of a conceptual metaphor for the way the intellectual property moves from the moment that it was developed to how it can be assigned to various people. So it starts out as the property of the employees, freelancers, subcontractors, and it will become now the property of you, the SaaS provider. And then you in turn are going to sort of either sell or license this to the customers and users. And in the top right-hand corner here, you'll see written agreements have to exist between each link in this chain. So that's, again, these IP transfer or work for hire agreements that I mentioned. The point is between every link in the chain, you know, each person should be signing an agreement with the other. Okay, I do just want to pause. I see a quick question from Dragos about open source software. Okay, we're gonna get to that later because that's a good question, and we'll talk about open source at the end because it touches on a couple things we'll talk about. Okay, quick timeout. We've been talking about sort of how to sort of form the company, how to make sure that your people helping you create it are assigning their intellectual property rights to you. What about this though? This is a special case. This is absolutely common for the last 15, 20 years in software development for companies in one country to outsource some of their particular development and engineering work, sometimes their sales work, but especially dev teams are often located India, Pakistan, Eastern Europe, you know, Poland, Ukraine, Ireland. A lot of folks in Ireland, you know, wherever it is, it is absolutely routine for development firms and SaaS providers to have international fleets of labor. That's fine. There's nothing wrong with that. It's become popular because it's fine. There's nothing wrong with it, and it's affordable. Slightly different wrinkles. Conceptually, you do want to treat your folks overseas, whether they're employees or contractors, you want to treat them the same at a high level in the sense that everyone should be signing these agreements. But depending on the country that they're in, it may be a slightly different approach. Key thing to know is well before you extend an offer to someone, well before, like as far as possible before, hopefully at least a few weeks before you do that, talk to your own business lawyer in the United States because that business lawyer is going to need to reach out to, well, the way it should work is they're going to reach out to a business law firm in whatever that other country is to get their blessing, because this is a risk issue for you if you don't do it the right way. So quick case in point, I had a client in Boston that's a distributed team. Last year, they decided, you know, they found this great person. This guy happened to be located in Tanzania. I'm not familiar with Tanzanian law. I'm not licensed to practice law in Tanzania, so I was not about to tell them how to do it. It was very simple. I reached out. I found an excellent law firm in Tanzania. They helped us work through some of the local issues of Tanzanian law. It's still basically the same contract that you would sign with your American folks, but you do need to adapt things slightly for the person on the ground in Tanzania. Oh, again, all very easy to do. Just remember, it can take some additional time, so just think through it with your lawyers. Okay, quick water break here. Now we're going to jump right into and look in some detail at the SaaS agreements. We've talked about them. Now we're going to go into more detail. SaaS agreements are not the only thing you need to understand when you're selling SaaS. You need to understand everything from pricing to how you compare to the competitors in the market. But my part of this is the legal side, so that's what I'm going to talk about. We're going to look in depth at them. Let me just back up a sec too. Generically, I'm referring to these as SaaS customer agreements. Now, depending on the preferences of you and your lawyer who's helping you write these things, you might call these something like a terms of use, terms of service, a customer agreement, client services agreement. Sometimes this is bubbled into a hybrid SaaS and services offering, so it might have a different name. It might be a master access agreement, whatever you want to call it. And all of those are fine. There's no, it doesn't have to be called one or the other. It sort of just depends on how you tend to talk about it internally. If you want to call it terms and conditions, call it terms and conditions. That's fine. All these generically, I'm just talking about the contract between you and either your customer or your users or both. Again, so the topic here is, what are the clauses that need to be in that contract, and what do you, what do you want to understand about them? By the way, let me actually pause on this too. Ideally, every SaaS provider will have what's called its own paper, its own template agreement. But the reality is, especially as you start dealing with larger clients or potential clients, they're going to be asking you to sign their paper. If you do a deal, I've done deals with like Google or Microsoft or any large, really well-known company. They're going to say, thanks very much for sending us your preferred template. We just shredded that. We're going to ask you to sign our master vendor agreement. And I do see we have a question from Martin. I'll chime in on that just 1 second. Thanks. That's fine. Part of the price of admission to working with the larger clients is often you do need to actually start negotiating off their contract. So fine. If you get a chance to sort of provide services to Microsoft, you should do it. You should pay whoever you need to pay to help you negotiate that. Don't be dissuaded just because it's their form. And the reality is, you can usually negotiate it somewhat, even though they tell you, they're all going to say, no, this is non-negotiable. Our legal said we cannot possibly negotiate section 17(3). What that means is ask them to negotiate. 8 out of 10 times, you can generally agree to get them to agree to some reasonable customizations. Do not buy the opening line that this is not negotiable. Do not ever buy that. At least try. If they're interested enough to even be talking to you, it means that you merely asking them will not cause you to lose the deal. So always at least try. Okay. So again, let's turn back to what should be appearing as clauses in the customer agreement. At a high level, basically, and this is cycling back to our first point, so we're going to return to this now. Again, the product that you're selling is the rights to use and access the product. So the platform, I mean. So typically the SaaS agreement, which we'll look at a real example in a second, is going to say that the provider is granting access, or sometimes it's called license, to the service. There's somewhat of a recent trend. Years ago, not that long ago, a lot of lawyers, including me, were writing this clauses as license clause. The consensus among lawyers is sort of switching over to calling this an access clause. I don't want to say it's a semantic difference, but it's something that don't be troubled if your current customer agreement refers to a license rather than access. There's some differences that come up with copyright law, but functionally they do the same thing, which is they are the permission that's needed by the customer to use your service. So sometimes it's access, sometimes it's license. And I'm sorry, I'm just trying to keep an eye on the Q&As, and I'll stop looking in multiple places. So sometimes, depending on the product, you are going to also give the customer, you as the provider are going to give the customer other rights, like, for example, the right to upload or download content, or the right to stream content. If you're Netflix, for example, if you look at Netflix's terms of use, they're going to give you the right to stream content. That only makes sense if you're a SaaS product that does that. Sometimes, depending on the product and depending on how you choose to work as a provider, you may choose to extend the access rights to other people. And this is just depending on how you want to work. There's no right or wrong way. Sometimes you may say this license or access right extends only to the individual. In the case of B2B SaaS, it extends only to the individual organization that is paying me. Sometimes you may agree, if you want, and you might want to get paid more to do this, you can agree that this particular company is also allowed to share access to the SaaS product with all of its parent companies and subsidiaries. So if you have a big institutional client that's part of like an international conglomerate with 20 different companies in the organization chart, you may be very happy as a provider to say, I've managed to make contact with this one company that's sort of halfway up the org chart. I would be delighted if they want to be my entree and let everyone in the entire organization worldwide get access to that too. But the point is, whatever you do, the contract should say that. Because if you are getting paid to have 500 people in the New York office use it, and then suddenly they're under the impression that they can have 12,000 people in 8 countries use it. You want to know that, and you probably want to get paid for that too. And again, depending on the rights that the customer is buying from you, they may also get the right to participate in like a user forum or a messaging feature. The bottom line is whatever the customer needs to be able to do with your product, the agreement should say that. It sounds obvious, but it does get important to negotiate that and be clear about that. Take a real example. We've all, again, become expert on Zoom recently. So let's take a look at their terms of service. This is an actual, like I just copied and pasted this. I removed with the ellipses here. I removed the parts that aren't particularly relevant here. But let's just take a look so we can start to see real life example of what all this sort of conceptual stuff means. Zoom. Remember I said there's sort of a trend recently towards people saying access as opposed to license? This is an example of one that says access. So Zoom, your customer, your use of and access to this website and all the stuff in it, the products, services, and associated software, collectively we're calling that the services. Your use and access is conditioned on your compliance with and acceptance of these terms. And then for good measure later in the document, they say, Zoom will provide the services and you may access and use the services in accordance with this agreement. Okay, pretty straightforward. This is a very common example of an access clause in a SaaS agreement. So if you have a SaaS agreement for your company right now, take a look at it, probably looks pretty similar. Although it may say license. Sorry, I went the wrong way. A couple more questions you might want to address in your customer agreement if this makes sense for your product. Again, not all products do this. If you're a product that has like a freemium approach, you've got a free version with limited functionality, the premium version of all the bells and whistles, the contract, of course, needs to make clear which version the person is getting. You don't want to have a situation where you don't really distinguish, and then you've got free users that are upset yelling at you because they said, well, I thought by using this, I was going to be able to use these other features. No, I haven't been paying to do it, but I just spent real time training all my employees to use all the features. And now I'm finding out that those are only available to the premium users. You're going to have a PR issue on your hands if you do that. You're not going to have to give a refund because it's the free version of the product, but you're going to have a PR problem. Or like a lot of SaaS companies, if you have sort of the good, better, best, or the gold, silver, platinum, pricing tiers, just be clear what people are getting for which feature sets. Okay. Does this, another issue to hit head on, you don't want to be silent on this issue, you want your agreement to answer this question preemptively. Does this subscription or this access that you're buying today also give the customer access to future versions or future updates that you may roll out? Usually the answer is yes, because at least for updates as opposed to like new versions, if it's a smaller update, generally you want your customers to have that because it either is good for you or it doesn't cost you anything to roll it out to them. But it can be trickier if you're offering a new version with enhanced functionality that's probably something you want to charge for. So you want your agreement to be clear on that. Also, if it's a B2B SaaS product, make sure that your agreement is clear on whether or not the access to the product also entitles the customer to customer support, onboarding, training. If by being a paying subscriber, they also get access to a 24/7 Slack customer support with your maybe your offshore 24-hour support team, great, say that. If they're not getting access to that, also make that clear, because what you don't want to have is a situation, and there are actually some state laws where the sort of the implication is that if you don't say that you've got customer support, then the law is going to presume that you are implicitly offering that. So if you're not offering that, you want to make it very clear that you're not offering that. And that's okay. I mean, the software world is one of those sectors where people are generally very comfortable using software without the option to have live customer support, at least for B2C and some B2B. All right, we're going to talk about a little bit of repetition here, but just to connect some dots. Again, in your SaaS agreement, you want to make it clear whether the customer is getting, in a B2B option, is it company-wide or per user? Depending on how your monetization strategy, you may want to charge a separate couple bucks for each user. Maybe you don't care, but just say what it is. Is it worldwide license? Is it only for the North America folks or the folks in Northern Africa or whatever? How long does the license last? You always want to give examples of situations. You always want to clarify what are the scenarios in which the provider can terminate, actually the customer too, but from the provider's perspective, you generally want to have two different varieties of termination scenarios. Usually you as the provider you want to have some option to just stop the relationship and cut off the customer's access for convenience. Just means you're not really giving a good reason. You're just sort of tired of working with this customer, or you're discontinuing this product. So maybe you don't have a problem with this particular customer, or maybe it's a it's a B2C product where you're no longer offering this particular B2C product. You need to have a way to legally cut off your users at that point without them sort of getting upset about it and suing you. So you usually have a long-term thing that'll say, on 60 days notice, I can just terminate this for convenience. And then you might have a different section that says for cause. In other words, if you've done something wrong, I can terminate you on a much shorter time frame. So it might say, for convenience, I can terminate you as a customer for 30 days or 60 days. For cause, for example, if you're not paying me my invoices every month, or if you have violated one of the terms of this agreement, in those kind of scenarios, or you've gone bankrupt, let's say, in those scenarios, I can cut you off either immediately or 7 days notice or 24 hours. In a B2B deal, those numbers and those clauses are going to often be negotiated. So just go into it with your own paper, your own agreement, take your best shot at how you'd like it to work, expect it to be negotiated. That's fine. That's part of figuring out what the market wants from you. As I said, the last bullet point here on this slide, scenarios where you want to terminate the customer are situations where they're violating your customer agreement. So what are some examples? You've probably seen these a lot. This particular one is my own template. Some of you who I actually work with, you've probably seen this language because I've put it in your SaaS agreements. I customize this for every client, so yours may look a little bit different. Sorry, I do see a question. Let me just take a look at that. Okay, yeah, Martin, I will get to your questions. Yeah, I'll cover some of those. Okay. These are some common examples of what we call restrictions on usage rights. In other words, this is what I sometimes call the 10 Commandments, things that thou shalt not do if you want to continue using my SaaS product that I'm making available to you. Basically bad stuff that if the customer does them, you want the ability, you don't necessarily have to kick them out right away, but you want the option to without penalty to you. So again, depends on the type of product you are, but these are common scenarios of things that a lot of SaaS providers would do. 3.2a, you don't want your customers giving your product to other people. Again, unless you've negotiated for that and gotten paid for that. You don't want them to sell it. You don't want them to resell it, license it, distribute it. You don't want them to rent any of the content, which people actually do. You don't want to also disclose them to other people without getting paid. So regardless of whether they're getting paid, you want to be the master of who gets access to your product. Now, you might very well, if you find that there's a big market for people that want to resell your product, there's a big market for reseller deals. You can literally, this is becoming more and more common in the last couple of years. Some of you I know have done these. You can absolutely work with a third party that's going to resell your product to other markets that they have unique access to or better ability to reach with lower costs of customer acquisition. That's great, but you should do that in the form of a different agreement. For this agreement, the vanilla contract for customers, if they are using your content, your SaaS product, they are not allowed to give it to other people or sell it. Section B, again, under the laundry list of things you don't want your customers doing, they can't use your product to store material that violates other people's rights. Pretty basic because that's a liability issue for you. If you have a sort of content neutral platform and unbeknownst to you, people are using it to store illegal stuff or harmful code or something, which is actually the next point, that's a liability issue for you. So you want to contractually make them promise not to do that. By the way, one of the people who are going to care a lot about you having this clause is your insurance company. If your insurance company, and we'll talk about insurance in a second, but they're going to want to see that you have things like this contractually obligating people to not do various risky things with your platform. Section C, I kind of touched on. You're going to want your customers to agree not to use your service to store or transmit malicious code. Anytime you see these initial capital phrases, that's like a defined phrase. So somewhere else in the agreement, it will have defined malicious code as like the laundry list of like, Trojan horses and malware and all the like the basically bad stuff. Other things you typically want people to agree not to do. You want to have them promise not to modify, copy, or create derivative works based on your platform itself or the content that they provide, that they find in it. So not only similar to the first point, they can't sell it, but they also can't just scrape content out of it and repurpose it. If any of you use the question and answer website called Quora, Quora, one of the problems that Quora has had in recent years is it's done very, very well. It's a question and answer website. You can just ask a question about any topic, someone will answer. One of you I know on this call happens to live in Park Slope in Brooklyn. If someone were to ask a question, where's the best sushi in Park Slope? Scott, you could answer that question if you wanted to. Anyway, that website has had a problem as it's become more popular. They've had a problem with third-party ripoff websites just scraping content, which totally violates the terms, but they're doing it, and try to repurpose it and resell core content because it's easy to do. So if you're that kind of a platform, you don't want people doing that. You don't want people to remove any proprietary marks. If you make your platform available, you're probably going to have your company's logo somewhere in the platform or in the interface. You don't want people somehow sort of removing that if they repurpose the content for internal usage. All right, one more question here. Okay, we'll get to that later. And then finally, section F, you don't want customers to disassemble or reverse engineer the product itself. This is particularly an issue because remember, if you're a B2B product, especially as you start gaining some traction in the market, you're going to have your competitors signing up to use your product because that's the best. And you probably, if you're smart, you're going to do the same thing. You're probably going to be, I shouldn't say if you're smart, if it's cost effective and if you are interested, it's a good idea to sign up and become very, very familiar with your competitors' products. If you're competing with some Google product or whatever it is, you want to know very, very well how that product works, not because you want to steal it, but because you need to understand the differences between that product and yours if you want to sell your product. You need to be able to explain to potential customers, here's exactly how we differ from that other one. So from your perspective as the provider, you may want to include things saying that your own competitors, while they may actually end up using your product, they can't use it to basically compete with you. All right. We can almost be done with this particular part of this. One more issue here is to say that sometimes the provider itself, in addition to giving access and license rights to its customers, sometimes it needs to go the other way too. And I'll explain what I mean, because this isn't really intuitive or obvious, but the SaaS provider, sometimes you need your own customers to give you a license to use the customer data or customer materials or documents, whatever it is that customers do with your own platform. So for example, we'll just work down the list here. If, and this, again, this depends on the nature of the SaaS product, so it may not apply to everyone. If you have a product which by its nature allows or requires the customer to upload or type in visual or written content or upload files to the platform. So for example, if you're Dropbox, your whole reason for existing is that you allow your customers to store stuff on your platform. Box, Dropbox, SugarSync, all these, those kind of companies. That's literally what they do. They say, I make a SaaS platform that you use to store your stuff. In that case, you need actually a copyright license from your own customers because, again, remember our previous conversation, by default under the law, anyone who writes something or creates some written work product or anything that can be protected by copyright, that person owns that stuff. No one else is allowed to use it without a written license or else they're committing copyright infringement. So what you do here, and obviously your customers want you to be able to use that, that's why they're using you. So to cover your butt, what you're gonna do is have a copyright license, and we'll see an example of this in a second, that says, the customer, am giving you, the service provider, the license to the copyright that's in all the stuff that I'm about to store on your platform or upload to your platform. Now trademark too, so as a quick recap of the IP laws, copyright generally protects written and visual expressions. Trademark is different. Trademark refers to basically ways that the company markets itself to the public at large. What that generally means is the company's logos, the name of the company, the name of the product in cases where the product is different from the company name, which is not everybody, but it's a lot of people. And then also, if there's stuff that the customer is going to need to put onto your platform or upload to your platform that's not protected by copyright or trademark, but if it's still secret information that they want you, or if it's, I'm sorry, if it's any information that they want you to display to the public, you need to make sure that there isn't an NDA clause that prevents you from doing that. So it'll make more sense in a second when we look at a real example. So let's do this. Again, the topic we're talking about here is situations where the provider's contract with the customers wants to carve out the right for the provider to do various things with the customer's own data. So let's look at one. Squarespace, a lot of you are familiar with. Some of you may use Squarespace. Great company. I've built a couple of websites with Squarespace. It's sort of, Squarespace came out of the blue, I don't know, 6 or 7 years ago with these awesome do-it-yourself website solutions. And here's an example of what the Squarespace terms of service says on this topic. So Squarespace here is talking to the customer. So you, if you're the person using the website to using the SaaS product to create your website. You, customer, you're granting us a perpetual, worldwide, royalty-free, non-exclusive right to use any portion of your websites, including names that may appear in there, trademarks, logos. You are giving us the right to use all that stuff. For what purpose? Well, it's the part that's in, I don't know what color you call this, pink, red. We can use that for Squarespace's own marketing and promotional activities, okay? You're giving us, in plain English, the right to reproduce your own intellectual property, the trademark logos, which normally we would need permission to use if we don't want to be committing trademark infringement. You're allowing us to use those to help advertise our own products. In fact, our customers are going to help us advertise. So that's fine. As long as it's in the written agreement, the customer agrees to it, there you go. It's an example of a way that you would want to reserve your rights to use customer materials for your own promotional activities. Again, it doesn't apply to everyone, but some of you that may. Another example, Salesforce, one of the world's most popular CRM solutions. Here's their version of this, 6.3. A license by the customer to SFDC, that's defined as basically Salesforce and its affiliate companies. Customer is granting to Salesforce a worldwide yada, yada, yada license to host, copy, use, transmit, and display the customer data, which is defined as basically anything that the customer pushes to Salesforce or uploads, types into Salesforce. You are allowing Salesforce to use that for what? Is it for marketing purposes? No, this is a different variation. Salesforce can use that as appropriate for Salesforce to provide the services. That's it. So it sounds sort of circular, but the point is here, Salesforce needs permission from its own customers to take, copy, and redisplay that same information back to the customers, and in some cases also to third parties who are using it. So that's it. In plain English, we can use your stuff to make the product work the way you want it to. Again, no customer is going to disagree with this, but you do want to have it in writing. Okay, how are we doing on time? We're making progress. We're going to skip to the next, not skip, we're just the next slide. Next part of the presentation, we're going to talk about common points of negotiation in B2B SaaS deals. Okay, these are some of the areas. We're still under the general heading of things that should appear in the contract, but now we're talking about things that tend to be pretty heavily negotiated in B2B SaaS deals. For B2C, you're not going to be negotiating these, but you do want to understand the issues because you need to sort of make sure your contract says what you want it to say. So B2B SaaS deals. Warranties. These are painful. I don't know anybody in their right mind who loves dealing with warranties. Lawyers hate them. People who aren't lawyers hate them even more because they're written in very hard to understand legalese. They're not like the sort of plain English part of the document. Warranties are one of those parts that are they're just painful, but you've got to do it. It's like paying your taxes. It's painful, but it's not an option not to do it. It's very risky to not do it. So what is a warranty? Okay, a warranty, think of it this way. In plain English, a warranty is the promise that the provider is making, or in some cases not making, to its customers and users, okay? The promises that you're making to your customers. And a big part of dealing with warranties in SaaS products, in SaaS agreements, a key job for you here is to actually make clear what you're not offering as a warranty. That's sort of more important than the actual warranties. So the big picture here, what you need to know, before we talk about what's going to appear in the contract, what you need to know is that state, and in some cases federal laws in the United States, provide default warranties. In other words, warranties that the court will say you have given to your customers by law, unless the contract overrules that by saying something different, okay? Again, the law supplies default warranties that the court will say, unless the contract says otherwise. In other words, if the contract says nothing at all on the topic of warranties, we are gonna imply into this contract a term that says that the provider is offered a particular type of warranty. So the good news is, in most states, you can generally override those by just saying so in the contract, because these are just default rules. So in consumer SaaS agreements, this is how this plays out. In consumer SaaS agreements, B2C, you're generally going to disclaim all warranties or have very limited warranties. Now in B2B SaaS, warranties are heavily negotiated. They're all over the place. Some companies will take exactly what you offer as warranties. Some of them will shred it and redline that document and ask you for something very different. Heavily negotiated, but there are some clear trends and generalizations that tend to prevail here. These change over time as the market becomes more comfortable with a particular type of risk issue that they understand. Because warranties are all about managing risk for both parties. But there are some trends that prevail with B2B SaaS, so let's talk about those. Generally, this is an example of some sort of warranty that most SaaS providers B2B anyway, need to provide to their customers. The warranty of uptime. In other words, if it's a SaaS product, to what extent am I promising that it's always going to be available for my customer to use? Every couple of years around Christmas time, there's an article that says, something like, if Amazon.com sort of goes down for, 30 seconds, how many millions of dollars of damage does that cause to all the sellers on Amazon.com? Okay, in a company like that, you can really understand what it means in terms of real world financial harm to have a website or a SaaS product even be unavailable for 5 seconds. It could cost you a lot of sales. Most of us are not Amazon, but we still have to be considering how we're going to make promises to people about how much the platform is going to be available to people. So these warranties can take a number of different forms. What I generally recommend is don't go for, the SLA is the name, the service level agreement is an example of like a long form of a warranty of uptime. Some of you have used those. It's usually a separate sort of an attachment to the agreement. It's usually very detailed, and it has sort of progressive tiers of if the product is down for more than 30 minutes once a month, then the customer will get some negotiated type of service credit on the next month's invoice. That's an example of the complicated way to do it. I would actually recommend, do that if you have to. Like go to that, that's sort of like a go to that if your customers make you get into an SLA. But 9 out of 10 times, at least when you're dealing with small and medium-sized customers, you can get away with just a simple short warranty clause that says something like the short version at the top. Provider hereby warrants that it will make commercially reasonable efforts to make the product available 24/7. I should say 365. 265 would be a terrible SLA. It'd be very generous to the provider. So I should say 365. But the provider is going to warrant that we will make commercially reasonable efforts to make it available 24/7. Okay? Commercially reasonable is the qualifier there. We're going to try very, very hard to make it available 24/7. What that means is if we occasionally are not available for half an hour or so, we're not in breach of our contract. We said we'd try hard. Commercially reasonable doesn't mean you have to do it. It means you need to try really hard. So all you need to know here is I recommend people in earlier stages of growth as a SaaS company, don't go right to the SLA. You go to SLAs if the customer forces you to, but generally you can get away with a simpler form. Also remember, let's see, warranties. Yeah, remember with your warranties, you generally want to disclaim any warranties that may apply to third-party software that are included with your deliverables, which in this case is just your SaaS product. What I mean by that is not all, but sort of most SaaS companies, the product, well, I should say some SaaS companies, the product that you are delivering and making available to people includes some combination of your own stuff that you've developed as a provider, as well as in some cases, content or products that you have via a partnership with a third party. Excuse me. So for example, you may have a license with Getty Images to not just display Getty Images photos on your website, but if you're a company that's actually in the business of helping people, with small businesses or something, you may have a partnership deal with Getty Images that says, we can actually make Getty content available through our own SaaS product. In that case, you would want to have a disclaimer that says, just to be clear, whatever warranties we're offering only apply to the part of the product that we built. To the extent there are any warranties that apply to Getty Images, you need to talk to Getty Images about this. We don't offer sort of extended third-party warranties on Getty stuff. We only apply to our stuff. Again, it may not apply to you, but it will apply to you. Keep it in the back of your mind because as you start to grow as a company, it becomes more and more common for SaaS providers to have partnerships or basically source various parts of the product from third parties. Finally, you also want to expressly, in other words, clearly in writing, usually in all caps, disclaim any warranties that are not already expressly identified in your agreement. These are 4 common warranties at the end here that basically many state laws say that, again, if you don't explicitly disclaim them, the law will say that you've offered them. So you want to disclaim those. We're going to talk about liability terms. Honestly, again, not one of those things that are particularly fun to negotiate, but it's sort of like indemnifications and warranties. Kind of need to understand. This is another area, much like warranties, that involves you as a provider managing the risk that is inherent in doing business. The way that you do this, the law provides you these tools called liability disclaimers and liability caps that are part of your contract. They're usually, one of those sections that's in all caps or bold because the law usually requires it to look differently from the other parts of the contract. it's all under the heading of how can you de-risk the deal for you as a provider. And one of the ways you do that with liability is to contractually override the default rules that are otherwise provided by the state law that you're dealing with, sometimes federal law. So the default rules, what are those default rules that we're trying to override? Well, generally the legal rules require the provider to compensate customers for harm that could be allegedly caused by the software. By default, the laws generally say that the provider has to compensate the customer for these types of damages unless the agreement says otherwise. So you always want to say otherwise. Let's take a look in a second at what this means more specifically. Here we go. For consumer SaaS, again, you're generally going to have pretty trivial liability that you agree to. You know, in some cases, you may be able to say in your customer agreement for consumer SaaS, we're not going to hold any liability at all. In some cases, you may say something like, we'll agree to liability that is capped at the amount of money that you spent to use our product for the last year or month or whatever it is, if it's a monthly or annual subscription. And usually that's fine because a lot of consumer SaaS products, the product is either free or it costs like a couple dollars a month. So let's go back to the example of Squarespace. I forget what their contract says on this point, but for the consumer, and it's not really consumer because a lot of people for Squarespace are business users, but let's just call it consumer SaaS. You know, the contract for Squarespace might very well say, if you ever sue us, the most you can recover, okay, the liability cap is going to be capped at the amount of fees that you've paid us for the last year. Squarespace, I think, is still something like $20 a year for the base package. So the most someone could possibly recover from Squarespace under that agreement is whatever, 20 times 12 months, right? Low amount of money. Now, B2B, very, very different animal. For those of you in B2B SaaS, you're going to need to really get into the weeds of this. Usually in B2B, you separate two different types of damages. Indirect damages, you're going to have, you know, you're going to agree to no liability at all. For direct damages, usually that's the part that's going to be capped. And, you know, there's sort of conventions about this. Typically, the provider will agree to a cap that's something like either a monthly multiple. And I represent companies on both sides of this deal. So usually when I'm representing the provider, which is kind of more often, I'll say, we agree that if you ever sue us for direct damages, at most you can recover 3 or 6 months worth of fees, okay? Now, depending on what those fees are, you want to put a lot of thought into whether it's 3 or 6 months. But the sort of convention is generally the provider says our cap will be 3 or 6 months fees. The customer, of course, will come back and say either, no limit at all, or we'll agree to 24 months fees. And then you sort of haggle that down and you meet at something like 12 months or 15 months or whatever. But the point is, you do want to have some sort of cap on direct damages. Also, sort of a pro tip here, you always want to disclaim the liability that could otherwise apply to you as a provider for the customer's data loss. And hand in hand with, in other words, say, I'm not going to be responsible for data loss at all. And as a reminder there, it's also a good idea to just sort of remind in the contract, remind the customer that because you're not responsible for the data loss, the customer itself should take responsibility for periodically backing up their own data. And the way this would play out, by the way, in the event of a lawsuit, like let's say, you know, the provider who is holding on to really important data held by its customers, you suffer a data loss event, the customer says to you, I didn't save any backups, like I'm going to sue you for losing my data. And that's when you're going to be very happy that you have included this clause in your contract that says, I don't know what to tell you, buddy. I told you right here in the contract, I'm not responsible for it. I reminded you of what you shouldn't really need reminding about, which is you should back up periodically anyway. No dice, no lawsuit. The lawsuit's going to be dismissed by the judge in your favor, which is going to save you, you know, $1 million. Let's talk about DPAs, data protection clauses. So data protection, just a note on the terminology here. Data protection is an interesting term because it can be used in two ways. First of all, for those of you who might be in Europe or do a lot of work with European clients, data protection is sort of the equivalent in Europe and in many other countries of what the United States legal system refers to privacy. It's not quite the same, but when we talk about GDPR, you know, the big European privacy law that took effect 2 years ago, that GDPR, it refers to data protection. It's roughly the same as what we in the United States talk about as privacy. However, there's a second meaning of data protection also in the United States, which is sort of a broader category of things that deal with privacy as well as sort of information technology security. So it's a little bit of a funky issue. All you need to know is whenever you see the phrase privacy or data protection in a contract, bottom line is it's something to discuss with your lawyer. That's just, there's not another way around it. It's very, very technical, and it gets really into the weeds very quickly. So, you know, you may remember 2 summers ago, it was May of 2 years ago, we started getting all these emails, actually it was before that, from companies saying we are updating our privacy clauses. That was because of GDPR, the new very aggressive data protection rule in Europe that took effect 2 years and 1 month ago, and is still sort of being implemented. It's been an interesting rollout over there. Now we started getting those emails again about a year ago because companies were preparing for the new California consumer, forget the acronym, CCPA, the big new California privacy law. It's not the first California privacy law. California has had various privacy laws that sort of lead the nation for years, but this is the big one that's in some ways similar to GDPR. And that's why we got all those emails starting last summer saying, you know, in preparation for CCPA in California, we're going to update our privacy policies. Why am I talking about this? What does this have in common with each other? Well, it's all part of data protection obligations that you as a provider need to be aware of. There are a couple ways you can do this, and the subheading on the slide is you can use short forms or actual DPAs. We'll talk about that in a second. DPAs can mean either data protection agreement or data protection addendum. So, and it can be either one, but colloquially, people in the SaaS space refer generically to DPAs. So just be aware it could refer to as a standalone data protection agreement, or in other cases, and this is fairly common too, it'll be an addendum, data protection addendum that it is attached like as an exhibit to a longer provider agreement. Of course, this would be in the case of a B2B deal, not really B2C. Why is this happening? Why is it is becoming, I call it the rise of data protection promises. These are another species of warranty. Why is this happening that these are becoming more popular? Well, there's a couple issues. One is just that data breaches are becoming just so much more popular. You know, not that long ago, you know, when you heard about a data breach with a company, it would be sort of like, oh, you know, they must have been doing something wrong. Fast forward a couple of years, we all know, you know, the cliche phrase is absolutely true. It's not a matter of if, it's a matter of when. Any decent sized company and some of the smaller ones will be hacked or will have some sort of, maybe it's not a hacker, some sort of data protection incident. They've just become more common. So it's therefore, in turn, it's become more common for companies to plan around these scenarios in their contracts. The other issue, of course, that's changed, is sort of related to the first point, is the changing laws. Again, GDPR, every time California updates its data protection laws, which is like every 7 years. And now it began with California, now it's Massachusetts, New Jersey, Maine, which is where I'm located and some of you are located. In some ways, Maine actually has the nation's most called progressive or aggressive data protection law, but it only applies to ISPs, so it's sort of limited. These things are changing by the day. So because the risk associated with those changes so often, so too do the contracts change. The other issue is the insurance industry is making finally some progress on having standardized policies that cover data protection issues and breaches. That wasn't the case. It's not like car insurance, which has been, insurance companies have been dealing with that for, I don't know, 100 years, whenever Henry Ford did his thing. But it's just, this is a more recent phenomenon. It takes the insurance industry years to catch up to the emerging threats. And over time, the insurance policies start to become standardized. The bottom line is that if you're in B2B SaaS, you're generally going to need to make some pretty robust promises, at least to larger customers, about the way that you maintain your security practices. We're going to talk about how to negotiate these. I'm not going to talk in detail about what should be in those DPAs because they can vary enormously. Again, my previous point, they can be negotiated. You can find plenty of templates on there. The key thing I want to tell you, before we even talk about what's going to be in them, DPAs are another one of those things where bigger companies are going to say, you have to sign our standard vendor DPA. It's non-negotiable. Always push back. You may not always win, but there's 2 ways you can push back. One is to say, completely try to dodge the issue by saying, no, I understand. If we were a different type of software vendor, absolutely, that would make sense for us. We'd be happy to sign that DPA. But we're not a work for hire software firm. We're a SaaS provider. And part of this is you and your lawyer needing to sort of educate the lawyer on the other side who sees these things, you know, all the day, and they sort of don't distinguish between different types of software vendors. Part of it is you having to educate the opposing lawyer, like, no, that's not what we're doing here. We're not a work for hire custom development firm. We are a SaaS provider. The nature of our SaaS product is such that we don't even have access or even a way to access your customers' data. So we shouldn't have to sign this DPA that is extremely difficult. It's going to cost us, a lot of money in legal fees to even look at this thing. So there's sort of a threshold issue here. Sometimes you can have what I call a quick kill. You can persuade the customer, not even ask you to sign the DPA. Your lawyer can help with that because sometimes you need to get the lawyer involved with that. In other cases where the customer says, okay, I get it. You're not the normal outside vendor. I still need you to sign the DPA because my insurance company is making you sign the DPA, which is part of this. It's not just them trying to be difficult. They really do need to sign these things. But in that kind of case, sometimes the best you can hope for, and this is surprisingly doable, is to say, okay, we'll sign it, but we're going to remove some of the more burden stuff. If there's an audit clause in there, in other words, a clause that says that at any given time, your customer can snoop around in the back end of your software product and kick the tires on it, you may want to negotiate to remove that, or say, this is what I like to do with audit clauses. I always try to get rid of them. If you do need to agree to the audit clause, say, fine, we'll be happy to agree to the audit clause, but you need to pay us an hourly rate of $150 an hour per engineer, or whatever you want to negotiate. We're going to treat that as a consulting gig if you do it. If you want to exercise that audit clause, you're going to pay us X dollars per hour for the time that we spend complying with it. Because an audit clause could be that your customer sends, I don't know, Ernst & Young over to spend a week poking around the back end of your software product. If you want to have engineers working on that for a week, you sure as heck may want to be paid for that. So that's one way to negotiate those. The other thing you can do is if they have ISO and SOC 2 certification, really technical certifications that you don't have because most companies don't. They're expensive, they're burdensome to have someone, to have your company be able to certify those. That's a common point of negotiation. Look at all those very granular certification requirements to say, no, we don't meet those requirements. We don't need to. You don't need us to. Again, part of this is just kind of sitting down and talking like human beings with the person on the other side. By the way, the trick to this is assume that you understand your product 1,000 times better than the lawyer on the other side, okay? The lawyer on the other side is a generalist. He or she understands these issues generally, but they of course don't know your product because this is the first time they're ever hearing of you. So in this case, your best ally is going to be your business contact on the other side. So it'd be you and your lawyer, whoever he or she is, working with the business lead on the other side to persuade his or her own in-house lawyer that it's okay to agree to this stuff. That's going to be your best ally to get this done quickly. Okay, we're getting near the end here, so let me skip the last couple slides and we'll do some questions, some of which we may have touched on, but we'll get to them. Okay, yeah, how to negotiate. Oh, yeah, I'm sorry. Let me add one more thing too. One way that you can sort of bring a quick kill to some of these data protection issues, it's sort of if any of you do any work with HIPAA compliance, if you have a product that is by its nature ever used in healthcare, some of you may, this is very similar to what happens with HIPAA, where in the HIPAA context, the client, if your client is like a hospital or doctor's office, they say, we need you to agree to this thing called a business associate agreement that basically helps them comply with HIPAA if you sign it. And one of the things, and those are a pain to sign. So one of the things you do is actually redesign your product. And this may actually not be that hard to do depending on the case that you're dealing with. In some cases, you redesign your own SaaS product in a way where you can say with a straight face to your customer, look, we've redesigned it. So we've encrypted your data before it even reaches our server. There's sort of an initial sort of moat that we build where you initially provide it to, maybe it's a third-party solution that will encrypt it or anonymize it or something before we even have the ability to see it. That can sometimes, and it sounds annoying to do that, but believe it or not, it can be less painful to do that than to actually agree to the business associate agreement or to agree to this rigorous DPA. So part of this is the threshold question of going to the customer and saying, for various reasons, I don't want to sign that, but how about this? In 2 hours, our engineer was able to design a new thing that basically scrambled your data before we even got into our database. If you can persuade them, and that might make for a long phone call, but it's going to be less painful than a lot of legal work to redo it and getting certifications. Okay, insurance coverage. Again, we're sort of into the end of the presentation now. Now we're just talking free form about miscellaneous issues that are going to come up. This is going to come up in two cases. First of all, you want to say right in your insurance, in some cases you want to say in a B2B SaaS agreement what your own insurance coverage is, because your customers are making you say that. Your customers want to de-risk the deal for themselves by requiring you in the contract to have certain types of insurance coverage. So what should you get? Well, basically, this will change over time as you get to be a larger and larger company. Your risk is going to grow, so your insurance coverage should keep up with that. But if you're in early stages, generally for B2C, you may not need insurance at all. Again, depends on the nature of your product. But if you make mobile video games, you don't need insurance for that. You just need a good contract where people promise not to sue you. If it's B2B, it is totally it's critical. It's not gonna be an option not to have insurance. And what I would do is just get it preemptively. Don't wait until you're having an interesting discussion with a potential first or second client. And for the first time, they casually say, right as they're about to sign the contract, they say, oh, by the way, my lawyer told me I should ask you what your insurance coverage is. That's the worst time to say, I don't have any insurance coverage. Let me spend 2 weeks trying to find some. That's the worst time to do it. You're going to have to get it, so just get it ahead of time. And what you want to get, at a minimum, you're going to have to get $1 million per occurrence for E&O, that's errors and omissions, basically mistakes that you make, general liability and cyber coverage. At a minimum, you're going to have to get $1 million per occurrence and either $1 or $2 million in aggregate. However, while you're talking to your insurance broker, and after this call, if you need names of insurance brokers, just email me, regardless of where you are in the country. It can be hard to find insurance brokers who really understand software. There's a guy I've been working with and sending clients to lately. I'll give you his name. His name is Dane Wise, D-A-I-N Wise. He's in Oklahoma. I forget the name of his firm. Look him up if you need insurance coverage, or email me. I'll introduce you to him. Send his contact info. But my point here is, while you're exploring minimum levels of coverage, just ask the broker, by the way, how much would it be additionally if I upgraded from 1 million to 5 million? Because for reasons that are not clear to me, you can't get like $2 or $3 million. You can get 1 or 5. Those are sort of the standard step ups. But in some cases, depending on the type of SaaS product you offer, it's actually surprisingly affordable to just pay like a little bit more to get $5 million. In other words, it may not be 5 times as much. It may be that you get 5 times the coverage for like 150% of the fees. If that's the case, seriously consider getting 5 million, because at some point you're going to need it. And it's going to be a point of negotiation with larger customers and B2B SaaS deals where they're going to require you to have 5 million. And then that way, if you've just bitten the bullet earlier and gotten 5 million, you can skip that entire part of the negotiation, which is often sort of painful. So just look into it. The point is, if it's affordable to just upgrade, just do it. If they say we can give you 5 million for an additional $1,000 a year, probably just do it. Okay, we're almost near the end here. Privacy policies. Nobody reads those things, right? Yes, that's absolutely right. Just what you all know intuitively. No one reads them. This has been proven time and time again by a number of academic studies. Really, nobody reads privacy policies for B2C SaaS. That doesn't mean it's not important. And let's distinguish here between B2B and B2C. For B2C, consumer SaaS products, you still need one even though no one reads one, partly because California law requires it. I'm not talking about the new California law that took effect a couple months ago. Just for 20 years, California's had a different policy, privacy policy that requires it. But the other thing is, if you don't have one, I can almost guarantee that you're in violation of the terms of use with some sort of software product that you're using. Facebook recently updated its privacy policy, its terms of use, to make it even clearer that if you use Facebook for any part of your marketing, or if you use Facebook's tools, like if some of you use Facebook Pixel, which is a marketing tool, or Facebook lead ads, or Facebook software developer kits, SDKs, if you use any of that stuff anyway in your product, you have entered into an agreement. It's Facebook's terms of use that says you yourself will have a privacy policy on your website. Facebook's requiring that in addition to California law requiring it. If you have a website, WordPress or Squarespace, they all in the terms of service require you to do this. So the point is, you just need to have one. That's for B2C SaaS. Again, for B2B SaaS, we're really more in the area of these detailed DPA kind of issues that I was talking about. Again, as I said, it's sort of similar to privacy, but that's going to be heavily negotiated. Okay, finally, I just want to give you a shopping list here. Whoever your business lawyer is, this is not one of those areas, if you don't have a business lawyer, you can work with anyone in the country. This is not one of those issues where you need to have a business lawyer in the same state where you're located. If you're in Oklahoma, but you want to work with an awesome lawyer you found in Texas or New Hampshire, whatever, that's great. Just find someone you like. Whoever your lawyer is, you want to make sure that you have the following legal documents in your toolkit. This is part of what you need to create and sell SaaS. And I'll distinguish customer-facing documents from the documents to be signed by your workforce. Customer-facing documents, you need a privacy policy. So some of this is just sort of recapping what we've already talked about, but just putting them into the form of a shopping list to ask your lawyer about. You need a privacy policy. You need a customer agreement, whatever you call that, terms of use or access agreement. In some cases, not all, some B2B SaaS products, you're also going to need a separate document, which is the end user license agreement. So the distinction here would be your organizational customer, the bank or whoever is your customer, supermarket, they are going to, no, that wouldn't be a good example, but the organizational customer is going to sign the customer agreement, and they in turn are going to make all of their end users, the individual employees or whoever, sign the EULA. In some cases, you need that data protection agreement we talked about. Some cases, you need the service level agreement, although as I said, try not to do that. Second category for your shopping list, for your workforce documents, all of your employees need to sign an agreement. All of your contractors need to sign a slightly different one. All of them need to have these IP assignment and NDA clauses. Optional, just optional. Some of you may be with companies that have begun to offer equity incentive, in other words, stocks or stock options to your employees, or in some cases, your employees and independent contractors, consultants. And nobody is requiring to do that. It's become very popular in the last 10 years with software companies, especially larger companies, but smaller ones too. There's a trend. So the point is, of course, if you are one of the companies that is doing that, that's going to be a separate document. So in closing, I need to give the lawyer's disclaimer. Hope you found this educational. We're going to get to questions in a second, but so I don't forget to say it. Hopefully you find this informational. Don't take it to the bank. I'm not your lawyer. I don't represent you. The firm doesn't represent you. Don't take this as gospel. Use this to think of ideas to discuss with your own lawyer. If you need a lawyer, you can email me. I'm going to give you 3 names. I always give 3 names. I'm not trying to pressure anyone to work with one law firm or another. I'll give you names of people that I like and help you find one, or accountants for that matter. Email me for the presentation if you don't get it from Kelsey, which you should. Go out and sell some SaaS. Finally, last thing before we get to questions, we just launched a new newsletter. If you want, it's on our website. You can Google it. But when you get the digital version of this PDF, you should also just be able to click this link